A dishonor of a check occurs whenever a check is returned unpaid for any reason whatsoever. Now this could be as simple as an insufficient amount of funds in the bank, or that the arrangement with the banker exceeded arrangements. For example, the person might have left instructions with their bank to not honor the check, or it could also be in an instance where the signatures don't match. So in all such instances, the check is returned unpaid for various reasons, and it is considered a dishonor of a check. So if you have been given a check which has been dishonored, you can proceed against the person who issued the check to you under various provisions of law. The primary provision to consider, and the most useful one to a person, would be Section 138 of the Negotiable Instruments Act. Now this is what is quite simply known as a check bounce complaint case. Now the prerequisite documents to file such a case are: first, the original check; second, the return memo; third, a statutory demand notice that you are required to issue to the person who had given you the check; and fourth, the postal receipt for that notice that you had issued. Coming to the statutory demand notice, so as soon as a check is returned unpaid and you are informed of the same, you have 30 days to issue a notice to the person requiring him to pay the amounts to you. If within 15 days of receiving this notice the amounts are still left unpaid, then you may proceed and file a check bounce complaint case against this person. There are other remedies also open to you. For example, you could file a civil suit, or you could even file a complaint case for offences such as cheating if they're applicable in such an instance. Now, the jurisdiction or the place where you're supposed to file a check bounce complaint case is the place where you had presented the check to be honoured. There was quite some confusion previously and for pending cases, as they had to be transferred from one court to another due to conflicting Supreme Court judgments and dicta of the administrative government. However, now this area of law has been clarified. If this is a new check that has bounced, then you are supposed to file the case before the territorial jurisdiction of the bank where the check was dishonoured. Ordinarily, the complainant himself should file the check bounce complaint case. However, if you've given a wakalatnama to your pleader or your advocate, he may file this. You could also issue a power of attorney in favor of a person to file the complaint on your behalf. However, it must be borne in mind that the complainant must necessarily appear before the magistrate and be examined on oath. A material alteration occurs when there is a change made on the check by another person. For example, I am given a blank check with just the amount filled in words, and I fill in the amount with a pen in numbers, and I fill in the date. Or the date is already put and I add a 1 before another number, or change it in any such manner. These are called material alterations. So if you're given a check with no date, with no amount on it, and just the signature, and you fill in the rest of the details, and such a check is dishonoured, and material alterations are found by the bank, then you will not be entitled to file a check bounce case. So it is always best to have the person who is giving you the check to fill out all the relevant details. How does one defend themselves from a frivolous check bounce case? Now, in certain business transactions, you may give someone a check as security. However, after the completion of the business transaction, this person might fraudulently try to encash the check that was given to them. The way to defend oneself from a frivolous check bounce case would be to show that there was no legally subsisting debt at the time the check was given to that person. Therefore, you will have to show that the check was given by way of a security and that no debt existed at that point of time. If you have been given a check by a company or a firm, then you may file the check bounce case in the name of the company, the firm, as well as the directors and the partners. That is, the persons who are responsible for the operation and the management of the company or the firm or the business at that point of time, at the relevant point of time, are all liable in a check bounce prosecution.